right, so we've had a lot of discussion of lawyers and non-lawyers and whatnot. And so I thought that it might be appropriate to begin my session, at least, by my calling on a colleague of mine who is an economist, God forsake. Ron, you want to report the news of the morning, which I think is really kind of a very interesting legal development by an economist from Missouri, raised in Iowa. So there's the legal word from an economist, but anyway, it struck me as a sufficiently interesting enough development to merit attention. Also, I want to begin this morning by what I mentioned yesterday is that I did not expect to be here, that Jody Freeman throughout our entire planning process was going to be the speaker, and then she went off to the climate change wars, and we caucused, and you lost, and you got me, so here I am. I will try and bridge this disciplinary gap. I will be a lawyer, and you will see that I will return to footnotes and feats and all those kind of things and details that will bore you silly. But I also taught for 15 years in the School of Public Affairs across the street, so I'm a little bit of a hybrid. All right. Okay. Who took it? You might have to look at that the whole time. Okay, so let's put where we are into some perspective. We started planning this conference about a year ago, just about a year ago. Thought that it was kind of interesting and maybe it's, a little bit of Harter's swan song and whatnot. So, but it turns out that it could not be more topical, more relevant. On this first full day in office, President Obama issued a memorandum to the heads of agencies that talked about government should be collaborative. Executive departments and agencies should solicit public feedback, assess, improve level of collaboration. Pretty strong words, as Lisa said, percolated up through some of the work groups leading on the campaign. But nonetheless, the first day of office issues this. Second one, same memo, different paragraph. Government should be participatory. Offer Americans increased opportunities to participate in policy. Provide government with the benefits of collective expertise. Interesting. Putting all this stuff, whatever this stuff is that we're talking about, into play. Next week announces another memo to agencies that wants to review the long-standing executive order that governs White House review. Parts of it are extraordinarily out of date. In fact, if you read the beginnings of 12866, it really just slams government. Don talked about sections 1 and 2. If you stop reading in sections 1 and 2, you just want to migrate, leave, because here's the President of the United States announcing that the federal government's an abject failure. So at least we're talking about renewing that. And clearly could include directives on collaborative government, whatever that might be. And so, in play, let's explore about it. So highly topical. What's happening 3 miles down the way? This talk, you see, 25 years of looking at it this way and how to do it right. What more arrogance could you get? It's just why I want to wear my prejudices, my biases right there on my sleeve. But on the other hand, I've been thinking about it for a long time, and having done an awful lot of these various kind of collaborations, sort of seen a lot of different aspects. My original article, which is now a little over 25 years old, on proposing negotiated rulemaking, which is a form of collaborative governance, to be sure, was really very highly tentative. To be quite frank, I didn't expect anybody to take it seriously. It was an academic exercise, and in one of the interesting tidbits of history, the real title ended in a question mark. is, should we try it? Question mark. And somehow the Georgetown Law Review, so when we're talking about negative parts, you can mention their name, unlike Kerwin yesterday, dropped off the question mark. So anyhow, it was a lot more tentative. But part of the idea of behind the article, lots of people talk about, it was to reduce judicial review, it was to do this, to do that. Part of it was just to get people talking. People didn't talk. And let me give you an example of not talking. The first Bregnag that I did was OSHA and benzene. And by the time I got involved, and I still remember well, my article was circulating in TypeScript, and the head of OSHA called me up, and his words were, quote, "Okay, wise ass, come try it." Gives you some idea of the setting of this thing. So we, by the time we got involved, benzene had been on OSHA's docket. OSHA had been working on it pretty much full time for 9 years. And the parties in those 9 years had only once been in the same room together. They all watched the oral arguments at the Supreme Court, and they sure as hell didn't talk to each other there. So the first day of the meeting of the Regnag, I've never been in a room where the tension level was so high. I turned to my colleague, an experienced mediator, so what do you do now? And he says, you tell a joke. And I said, have at it. And he said, well, you may wonder why we invited you here, but if nothing else, you'll learn that you don't like each other. And no one laughed. At any rate, benzene was the first health standard that OSHA was not sued on. It tells you a little, interesting kind of development. So anyhow, part of the idea was just to get people talking. And so much of what I'm going to talk about, not surprisingly, is going to be about Regnag, because that's where my experience lies. But the theory and the issues and a lot of the problems are really equal, or are very much the same across collaborations of all sorts. And I think that Jody Freeman did just sort of a wonderful job of both redefining it from negotiated rulemaking, which is very narrow and sort of conjures up lawyers and all those kinds of things, but generalized it and everything. So I think it was just a terrific aspect. So both my article and the administrative conference recommendations identify at the end, saying, well, this is a great idea, but. And so it raises a number of issues. Well, the agency might be reluctant to lose control. Well, the agency might believe it's in a better position to put together the collaborators than anybody else. The process might take too long and be too resource intensive. And the agency may say, thank you very much, but no, we're going to make fundamental changes. So this was way back in 1981, I think in the formal conference recommendation. So does all this sound familiar? Sure does. Still the relevant questions. I think that one of the things that is really exciting about the whole idea of collaborative governance, I missed my own cue here. There you go. Is that there is really a vast array. If you look at the literature, just where they're happening, what types, just a huge number from local planning, local decisions, local land uses that have major impact, like the one that Chris gave yesterday, of the whole idea of the deliberative democracy that Lisa talked about, of strengthening understandings, working out disagreements, coming up with recommendations, bringing together a cohesion, a broad range of people and organizations, really kind of extraordinary interests in resolving cases, certainly. And there's no question that collaboration can be used in a number of different ways in the regulatory process, subject of sort of Washington kinds of things. Could be a scoping session. What kind of issues do we need to take about? I think that may have been one of the examples given here. What needs to be on the table? Could be a policy dialogue or roundtable in which the science or other important components discussed, debated, and maybe even some agreements on it. Can be, quite specific kind of recommendations, or it could actually be an agreement on the policy itself. Each of those is important, has a critical role to play in government, but it also strikes me that it is absolutely essential that everyone, agency participants alike, be clear on what the goal is from the get-go, from the outset. To a very real extent, the process used in collaborating is a function of the outcome desired. So you're going to do different things depending on what the use is going to be. And it can be really quite counterproductive to start in one direction and say, oh, by the way, we changed our mind. People can be badly hurt by that, people can be angry by that, and it certainly can significantly diminish trust. Or as one participant quipped, who participates in these fairly frequently, says, you know, you have to know where you're going before you know whether you've gotten there. And so to a certain extent, you've got to be clear what your goal is. Just a couple of years ago, there was a joint memorandum issued by OMB and the Council of Environmental Quality on basic principles for environmental conflict resolution. And one of those principles is to ensure that all participants and public are fully informed in a timely manner of the purpose and objectives of the process. So, pretty important. And I think, maybe this is, again, the lawyer in me, interested in the topologies and everything, is I think that it's important to get a definition to address the various kinds of collaboration. And as David was talking about, I'm sort of reminded of the Supreme Court decision saying, English law and American law are separated by a common language. And so, at least from my vantage point, I think it ends up being important to differentiate collaborative governance where the agreement or where the working together is actually entering into government, imposing obligations, everything on other people, as opposed to collaborative management, where management is doing it. Anyway. But along those lines, at least for my purpose, I want to agree heartily with Chris's definition of collaborative governance and emphasize two parts of it. First of all, he requires, in his definition, an agreement. So it is different from a policy dialogue, it is different from a roundtable, but this is actually, it is the parties agree, and part of that agreement is that the agreement will be implemented. I'm of the view that it is better usually to have that it will be implemented by one of the parties to the agreement and supported by the others. But if there's a close enough one, maybe close enough for government work. But anyhow, I'm going to get back to that in a bit. I think that it is essential. The agreement part, from my observation, is required for a seriousness of purpose on the part of the collaborators. Collaboration is hard work. Collaboration is, in law school, people sort of really like to, cherish the old litigator regime, even though it was, talked about yesterday that 90% of the cases are settled. But, people like the swagger of the litigator. And you hear a lot of times from the litigator, negotiation is soft stuff. That strikes me a little bit like the bomber pilot saying the infantry isn't real war. Have you ever heard a litigator say, I wrote a horrible brief? Now, it's always the judge's fault, right? Or the jury didn't understand, the dumbos. But in the infantry, you're nose to nose. And in the negotiation, you're nose to nose. And it's hard work. So anyway, you want to do it in order for the outcome. The seriousness of purpose. You can walk into a room and know whether what's on the table, are you negotiating an agreement that will be implemented or not? I had dinner with a bunch of mediators a couple nights ago, and they didn't, their view was, if you can't see any perspiration on the forehead, it ain't real. So anyhow, I think that's an important dimension of the Chris's definition. And I think that the reason to emphasize the implementation is that there are instances in which the parties reach agreement and people have no intention of implementing it. Interestingly, EPA's asbestos rule was that, and I never did quite understand what was going on in it. But nobody really had any intention that it was going to be done. Okay. Let's look at why an agency might want to use it. David denounced it. Ain't going to happen at EPA, by God. Well, it hasn't recently, but it did, and there were some really kind of remarkable results that came out of it. And let's sort of look at some of the reasons why an agency might use it. First one, perhaps the clearest, is it's stuck. Neil talked about flight duty time that he had tried multiple times, and he missed the great metaphor, because of course the answer is, FAA proposes one way and one group shoots it down. So if you're going to talk airplanes, you've got to talk about shooting it down if you're going to be opposing the... But at any rate, so it couldn't do it. I mean, the OSHA steel one, OSHA had been actively on OSHA's docket for 17 years. It was the largest source of accident deaths every year, or something like that, I don't know, close. Just didn't get it done, because one thing, multiple parts. Another reason to use it is to help diminish debilitating controversy. And this is one where I think that it's important to look at the fact that an agency may well have the authority to issue a rule, but lacks the power to do so. And in this city, don't confuse the two. And so it may well lack the ability to get the decision out the door. And I can think of several regnegs that were done preemptively because they said that it would be so controversial that it would just be tied up in the agency forever, so let's try the negotiation. Another reason is to acquire better information. It may be technical. The agency really does not have state-of-the-art information, and it needs it from the private sector. And the private sector, frankly, doesn't trust the agency enough to give it to them. And so actually sitting there in a way where you can control its use, control how it's going to be implemented, is a way that makes it safe to give it to the agency. It may be that the relevant choices are in the private sector as to which road of technology is going to be followed. In other words, there may be no clear choice. There may be multiple ways of addressing the issue. And it's unclear which route the regulation should go down if you can't do a general performance standard. Another one is to really overcome a significant amount of distrust. People just don't trust the agency, don't like it, don't follow it, don't believe in it, and so there's a way of regaining that. I sent this brochure off to a friend in local government, and who sent me back a document that he had been given that sort of said that was a significant thing of hampering, so it's a significant aspect of hampering local governments. There's this lack of trust in their abilities. Another one is to build a public legitimacy, somehow making sure that it's broad-based is a way of enhancing the acceptability of the choice made. And I think another one is a recognition of the changing nature of public-private relationship. Is that before you could kind of argue that. I look down and I got 3 minutes already. So it's you could just sort of talk about the public sphere and the private sphere were different or whatnot, but there's a recognition they're a lot more interdependent. Information, how it's going to get implemented, feedback loops, a lot of more regulations are more specific as command and control has run its course. And government, a lot of times, is just a lot more dependent on the private sector than it used to be. Another aspect of using collaboration of one sort or another is, frankly, just synergy, just the development of ideas. Taking it, hey, that's a good idea, what if? Just brainstorming, creative, stimulate each other's thinking, fostering creative ideas. And pretty clear in my observation, up close, firsthand, personal, whatever, that doing so often has considerable benefits. It's been a long time since I've made a study, and it was pretty cursory to begin with. But I took a look at maybe 5 or 6 different regulations and came up with a really relatively startling conclusion. It is clear that every one of them that I looked at was significantly more stringent than the agency would have issued on its own, and yet cheaper to implement. Bizarre. And the answer to it is that the folks in the private sector could figure out how to get the biggest bang for the buck. And just as a footnote to that, for example, the gasoline standard, the reformulated gasoline standard, the requirement is lower than, more stringent than the environmentalist going-in position. Grab that. I mean, really, fairly interesting, startling result. Another aspect, this is my tribute to the economists and to OIRA here, the techie analysis, is that a negotiation really is the way to set up the Cozian bargain. And the Coase posits that left alone, parties could negotiate an agreement as to exactly where the regulation ought to be set in order to for the sweet spot where the marginal costs equal the marginal returns. This is the way of getting it done, and by its nature, it's Pareto optimal. So it's going to not leave bargains on the table. So one of the reasons you do it is to get some of these better results. But before we get there, and this is the lawyer part of me, is let's talk about some plumbing, the details. It's a nice house, but we've got to talk about the infrastructure of the plumbing. And one of the reasons I want to emphasize this is so much of the discussion of collaboration is at a very high level of abstraction and generality. And it takes a lot more to get it done. You need to understand, I think, a little bit of the details. And at least in my view, and this is my 50 years of getting it right, by God, is that it's a very flexible process, no doubt of that. But it's not formless. I mean, there are nodes in the system, so you can have the amplifications going on, but there are some points you gotta look at. So let's look at some of the conceptual views of it. I find it most helpful to think about it in terms of a form of representational democracy. Representatives in democracy. And so in a lot of ways, you can look at it as an alternative way of ensuring representation. Now let's think about it. Let's take a look at modern elections. Let's look at those wonderful gerrymandered polygons. I mean, there's a congressional district that Ron and I are in, extends from Columbia to Hannibal, Missouri, 120 miles away in a corridor, 5 miles wide, something like that? I mean, this election is good. They're guaranteed. And why are they done that way? Well, they're done in order to secure results in advance. And that's one of the reasons for the breakdown of democracy in Congress, because all the seats are solid because of gerrymandered representative. And let's look at another aspect. If you have a widely dispersed interest that represents 48% of the entire population, but the anti-proposition represents 52%, that interest will not ever have a word mentioned in Congress or in the election. So, when people want to talk about, this is on interest selection or whatever, yeah, well, let's look at the alternative, and it ain't pretty. Now, in collaboration, are you going to get everybody? No. But neither is anybody else. Neither is any other process. I mean, some of the ones we're talking about, some of the deliberative democracy. Let's get the people involved. I spent a lot of time in Vermont. At the last town meeting, our town of 4,000, how many came to our town meeting? 200. Pretty narrow representation, actually. If you look at the dynamics of it, it was one sector clearly dominated. So, some of the alternatives, have some significant issues. So, if you want to look at collaboration, what are you really looking for to be a representational democracy? You need enough diversity to make sure the issues are on the table and raised, and a check so that others can make themselves known. Recognizes the relative strengths, benefits of the public-private spheres. Now let's look at what the government's role is, because I think that it really is important. I'm going to come back to it several times. The government, critically, reflects the public will as distributed, for better or for worse, through the legislator, and through the legislative dictates. It sets and enforces the goals and boundaries. The ECR basic principles I mentioned before, it communicates, the agency is directed to communicate agency authority, requirements, and constraints. So it's important to get this up front. The government gathers and analyzes the data. So typically, the agency staff will be the one that acquires the necessary technical data, but I'm going to come back to that in a second. And the government clearly is the one that's going to push people to come to the table. A lot of people say, I don't want to reg on that. And the agency may say, well, yeah, you might prefer to participate in it than the one we might issue. So it's going to be the one to push. Private sector, really, that's where the how-to comes from. And it's also where the state-of-the-art comes from, the real technical information. And it's one as to where what the effects, both positive and negative, of a policy choice will be. A lot of times people are simply operating in the dark otherwise. And then you have the other various players, pushing in on it. So, for the plumbing, putting it together. First question is, who are those guys? One of my great lines in movies, it's just... it's critical in any kind of collaboration to know, well, who are the collaborators? It's really wonderful. Collaboration has a positive ring. If you look at the dictionary definition of collaborators, it's treason. So, it has this wonderful kind of side definition here. But it's really essential to know who were those guys? As Earl was going through his talk yesterday, because, but who is it that's writing the standards, which you later got to at the end. But doesn't it change when you know who's sitting around the table? Know what the issues were, and I think Michael raised that some on needing to know that in judicial review. So the value of what you have depends on who did it, who produced it. And that's true both inclusively and exclusively. Was anybody left out? Why? Was it padded with your friends? And why? So, and then lastly is how hard you look. Did you just say, hey guys, come to the party, or did you actually go over and turn over some rocks to see if you could find it? And I think that congregating the committee, putting it together, is really essential. For political legitimacy, it's important to ensure that the appropriate interests are in fact represented in the deliberation and the resulting agreement. If somebody's excluded, even if it's totally beneficial to them, sort of the idea of procedural justice is you have an enemy. You didn't ask. I was not invited. Another aspect is to make sure that you really have the full range of insight and information. Lastly is to ensure that your handiwork doesn't get knocked down. I've certainly seen agencies say, well, I'm not going to have that son of a bitch participate in here because I don't like it. And it's the very person who's going to sue him. And he goes, this is nuts. So part of the one is you're going to need to make sure these people are in the tent, to follow Lyndon Johnson's metaphor. So somebody needs to put it together. And I think that just a couple things to put it together. It really does need to be an outreach. Somebody needs to make a concerted effort to find out the various interests that are going to be represented. And notice that the word organized was not there. You don't have to have a trade association. You need to figure out what kind of impact is this going to have, and can you find people to represent it. And I think that another thing to emphasize here is that candor is important. That it is a mistake for a party in the situation to try and game the agency or the convener. You're going to get found out, and you're going to get hammered once it does. And for the convener to be upfront and honest with the agency, if not, some bad things can happen. And I think that there are another aspect that commonly comes up is the convener will be out there talking to people, getting their candid views, and the convener will come and talk to an agency, and the first thing the agency will say is, tell me what everybody said. Well, exactly what you don't want to happen. And as in the example, or yesterday we were talking about agencies doing stupid things. I mean, there is currently an agency that has sent a letter to a convener saying, we want all your confidential records. And if you don't give them to us, we're going to blacklist you and make sure you will never be hired again by a federal agency, and we're going to sue you for the papers. And then he proceeds to go on in a legal opinion that is just flat wrong as to 3 statutes. So anyway, the mindset, I mean, stupid legally, stupid policy. I don't have very strong feelings about it, however. So it's at any rate, why do they do this? At any rate, so it is a form of outreach. It is a form of extending out and getting people in. It is also important. This is a form of representational democracy, and so it's important for each of the interests to select its own representatives. And sometimes it may take 2 or 3 different people to represent the full range and breadth of that interest, but it's up to the group, not the agency, to select it. Why do agencies want to control? And there's a renegade going on today, this very day, in which the agency said, you're going to be this representative for this party. Why? It's not a way exactly to get the folks on board. One of the things along the line need to decide is it worth the candle to hold a collaboration? I mean, it may be that just chances are remote that the group will reach an agreement. It may still be worthwhile. I mean, you still might want to converge, or, I mean, there are other reasons why you want to do it, but you need to get some kind of idea. If the purpose is an agreement to be implemented, then you have to get some kind of idea. And there are a whole series of criteria. Different people use different ones. There's one in the Reg-Nag Act. Different people, as I say. But essentially what it boils down is the outcome is uncertain for everyone. Everyone. Notice that includes the agency. And sometimes getting an agency to admit that it doesn't quite know what the outcome's going to be, and indeed whether it's going to get the rule out, is sometimes hard to fess up. But anyhow, so the outcome is uncertain. And the reason why this is a criteria is, hey, if one party knows what the answer is, why negotiate? You got nothing left to talk unless there is some other external reason, and that external, well, never mind, there's a feedback loop there. Another one is some decision is likely to happen in the future. The third, then, is that the parties are likely to want to participate in order to control that decision. So there's a sense of urgency. I don't know what's going to happen, but if given the opportunity, I'd like to be there and help steer it, as the metaphor we've been using talks about. I think that another important aspect, one that was not in the original criteria, but I think that is growing in importance, is that the agency is willing to use the process to base its decision on and participate actively in it. Now let me sort of elaborate a bit on that. I found, my guess is that everybody else has found, that agencies are spectacularly creative in sabotaging things they don't like. They'll say, we are really interested in your collaboration. Go out and collaborate. Bring me the agreement, and I will read it, and I will promise to you that I will give you a decision in, 10, 15, 20 years. Or I only made one change. I put not before the main verb. I had that happen. I've seen it. Or just nothing happens. The early history of the offeror process at the Consumer Product Safety Commission was just a case study in agency lethargy and rejecting proposals that came to it. So you need to know that, they're interested in it. And they also need to participate actively in it, which I'll get to in a minute. In the last 10 years, no, actually the last 12 years, there's a new one. Is the agency, staff and management, staff and political, career and political, on the same page and communicating? More on that later, too. But that has become, I think, an essential part of putting together a successful collaboration. Convening report. After you get done, it doesn't have to be elaborate. It doesn't have to be War and Peace. It needs to be the War. Anyhow, it can be really actually fairly short, describing whether these criteria are met and what the various interests are and what the issues might be. And then sort of make a recommendation. One of the reasons I emphasize that is it has really a very important role. It serves as kind of the boundaries of the negotiation. This is what it's about. And so that relieves a huge amount of anxiety as the parties get to the table. I know what it's about, and more importantly, I know what it's not about. So I can come prepared to focus on it. I mean, the amount of anxiety reduction, knowing what the thing is about, getting the ground rules up front is really critical. And so it also then speeds the negotiation because then you can build on this. I think another aspect is, are you going to get everybody? Absolutely not. Never. No process. And boy, do the law professors love to say, how are you not going to get everybody in a regnag? As if all 260 million people issue comments. And, you know, the Forest Service only had a mere 4 million on the roadless rule, and look how wonderful that worked. So, you know, you're not going to get everybody. You don't get everybody in a town meeting. But again, you need the diversity. You need for representation, and you need a means for someone who thinks that they would be affected, but somehow weren't contacted, and their views are significantly different than anybody at the table, to come forward and participate. After all, if this is a representational democracy, I'm not represented. I need to be represented. And my perfect example of that was on a Clean Air Act rule that actually resulted in a phenomenal end-up decision. The Air Pollution Control Officer of Jefferson County, Kentucky, came forward and said, I'd like to participate. I mean, I could have looked for squillion years and never found this guy. And he was the hero. He was both a lawyer and a PE, and he was kind of the internal mediator. And it was spectacular. So it's a way of getting it. So anyway, the notice of intent, somehow getting the notice out broadly, is ensuring, again, the legitimacy to make sure that everybody can be represented. It's a check on the whole convening process and can build it up. It also, I think, has an interesting effect on judicial review. And what it says is, hey, guys, this is where the decision's going to be made. And somebody yesterday mentioned saying, Neil was talking about don't go behind the back of the group. What this is communicating to all interests, this is where the decision is. So don't sit and think you're going to wait and go around into judicial review. So it ends up having multiple roles. All right, so let's look at consensus. Or, if the purpose of an agreement or if the purpose of a collaboration is an agreement, what do we mean by an agreement? It needs to be defined. And so you talk about consensus. And consensus is really kind of an interesting word that is really often misunderstood. I mean, if you look at the dictionary definition, it's majority, general feeling, unanimity. Fourth definition, worthless. So you need some kind of understanding up front. And I think it's important to dispel a bunch of the errors in it. Typically used derisively to mean a decision that's the consequence of a groupthink. No analysis, no exploration of the issues. So the boss saying, do we all agree? Good, we have a consensus. So that consensus. It really is the lowest common denominator. It's the acquiescence of an accepted point of view. And interestingly, I mean, in that context, a consensus can be actually more severe than the opinion of any one of the members. And so-called cascade, everybody tries to outdo the other, can reach kind of bad results. Another aspect of it says, gee, it's going to result in the least common denominator. You wouldn't want it. If you need it, it's just going to be so watered down, so bland, it's going to be worthless. And there are really a whole bunch of articles in the legal literature, at least, that posit that with neither understanding nor research as to actually what a consensus in this does. Interestingly, if done right, a consensus has exactly the opposite result and results in the wisdom of crowds. So stay tuned here. In the context of a collaborative governance, it's really critical. The definition of consensus is important in reaching an agreement and in the quality of it. So let's take a look at it. By and large, usually, not always, as we heard yesterday on the OSHA crane rule, it was everybody except two could dissent. Usually, it's each interest needs to concur, which gives, notice what the flip side of that is that each interest has a veto over the decision. Immediately say, it can't be done, right? Well, let's take a look at what it does. First of all, it makes it safe to come to the table. If I have a veto, then at least for the time being, I don't have to build power. I don't have to keep packing my six gun that Chris was talking about, because I can talk at the table. Whereas if it's going to vote, even if it's going to vote in two people, I might be the one of those two. I'm going to start building power. I'm going to go talk to my congressman. I'm going to go talk to OIRA, and I'm going to talk to anybody who will listen, and probably a great number of people who aren't. I'm going to keep building power. So it makes it safe. Another thing that it does, and this I appreciate, this is going to sound really strange, but what it does, and I think to a certain extent, if you listen to Chris's description of his Wild West example of it, it converts the group from a group of antagonistic, often hostile participants into a committee with a common purpose. We need to reach a mutually acceptable decision here and get the hell out of here so then we can start shooting at each other again. But you can feel it happen. You can feel it when that committee comes together and becomes productive like that. It's just a fascinating, there's just a snap in the room. Usually after the third meeting, whatever, one side yells at one, then the other side, and then sort of come together. but so it converts at that. Another thing that it does, and again, this is why the unanimity is important, it forces the parties to deal with each other. How many of you have been in a meeting and somebody says something and you think it's wacko, and you say, I got the votes, let's vote. I'm going to roll you. And that does not produce good decisions, and it certainly doesn't produce a lot of trust. So what it does is it produces the friction, the clash of ideas. That is the essence of deliberation. It is the whole basis of the wisdom of crowds and whatnot. Part of the definition comes from there. It also enables the parties to make if, but only if, decisions. Notice that if it's not a consensus, if it's a voting, or if it's only a recommendation, an agent, a company, an environmental group cannot say, I can do A if, but only if, you do B. Because you've just given away A, and you ain't sure you're getting B. And so it enables you to make a much more sophisticated decision than you can through an other decision process. Interestingly, and in talking, sort of following on some of Don's remarks, it greatly reduces the amount of paperwork. Have you ever noticed that in any kind of trial or anything where some molecule of interest is at stake, all this information comes pouring in, and just stuff that is well beyond any kind of respectable science or fact-finding. Why is that? Well, you do it because you don't have control over the decision-maker, the judge, the agency, OIRA, whoever it is that's going to decide. And if you win on the facts, you've constrained the decision on the law or on the policy. But if it's a real collaboration where it's consensus, you are the decision-maker. And a lot of times, you don't need to resolve those scientific questions. You don't need to know exactly the dose-response curve of benzene. You don't need to know exactly the costs or whatever. The question is, as responsible professionals, what are we going to do about it? We recognize a health risk. What is a responsible response? So it can significantly reduce the amount of a record. Another aspect is that a consensus is taken as to the whole, and so it forces you to look at an entire agreement. So you see the trade-offs. I think one of the greatest single failures, an example of the other way, is EPA's Common Sense Initiative. We're going to have a consensus on every issue. I mean, you can't agree on your name if you're going to have a consensus on every single issue for lots of different reasons. But anyhow, so it forces you to take a look at the whole. And importantly, for what's been battered around this room a lot, it pretty much means that you're not going to stray very far at least, from the statutory mandate. Why? Because the statutory mandate is going to benefit some party. And so that's going to pull it back into the orbit. So it has sort of lots of aspects. It also, I think, will tend to help in implementation. Agreement, I think important to look at that it's still up to the agency, up to the government to make the final decision. So even if it's going to be implemented, it's the agency's commitment that, yes, we will do everything necessary, but it's likely to be converted. So let's look at some of the conceptual. Oh, all right, there you go. The but is, if the agency just cavalierly disregards it, it has now created a major political issue for itself. So it clearly has the authority. Everybody understands the authority, but if you just sort of trash it, you now have a political issue that will be dealt with in another issue. So let's look at some of the conceptual criticisms of the literature. One is it may push the statutory envelope. Famous wood stove example. Let me give you a little bit of background on the wood stove. What is the complaint about the wood stove issue? It's not that it doesn't comply with the Clean Air Act. Or it complies fully with the Clean Air Act. The issue is a wood stove is a consumer product, not a stationary source. So the argument is Clean Air Act doesn't apply to it at all. But here the wood stove group is saying, yeah, regulate us under the Clean Air Act. And so that was the fight under wood stoves. And the interesting part is everybody says, oh, isn't this terrible? So, here the committee negotiated and warped the Clean Air Act. Well, I will tell you, it was EPA put that on the table, nobody else. And so the problem with it is, but EPA wasn't sued. Oh, everybody was happy with the rule. What a terrible outcome. If that's as bad as it gets, I think I'll rest my case. And I guess one final story is that when I bought my new wood stove in Vermont, I bought it from a woodchuck, which is a Vermont redneck, but anyhow, a woodchuck in Vermont. And I told him my involvement in it, and he had cracked this Green Mountain smile and said, you got it just about right. And I'll tell you, compliments don't get any better than that. So anyway, it's a good rule that has a sort of peculiar aspect. All right, so it may push the statutory envelope. Another one, changes the nature of the agency. So that only agencies can determine the public interest. We've actually heard that a couple of times, which I just love. Where does the public interest live? Which rock do you turn over? Or is it that brooding omnipresence that Holmes said didn't exist, or do you need magic glasses, or that it decenters the agency from czar to mere participant? It's no longer seen as the expert decision maker. You also hear that it can't tackle the complex, difficult issues, which I find just ludicrous, because that's when you use it. You use it that have been so controversial that the agencies can't do it. So let's look at some of these. It really isn't delegation because the agency has to concur. And you can say, okay, people allege that the agency will cave just in order to reach agreement. I'll tell you, I have never seen that happen. I mean, maybe it's happened to somebody else, not in the room that I have been. And even if it did, if it really caved, it strikes me that some oversight committee in Congress is going to hammer it pretty good. And there's a major political incentive not to have that happen. Is there likely to be unhappiness inside the agency? Yup. I mean, some people, no question about it, are offended by the agency actually talking to those guys. But, agencies aren't monoliths. There's a fight. There's a reason that there is, paragraph 5 in the B5 in the Freedom of Information Act encourage that kind of debate. Is the result different as a negotiation? Boy, I sure hope so. That's why you're doing it. And whatnot. And so, probably achieve the goal better. And so it strikes me that the objective of the agency is likely to be the same as it would be in any other kind of process. It's going to be the same expert and all these other kind of things. But I think for it to be successful, it's going to have a different attitude, And if you look at sort of a lot of the justification of what we've done in administrative law by forcing all these kind of aspects into pushing a rational decision, sort of the civic republicanism is broadened from just internal to the agency to broader across the entire spectrum. It seems to me where we are right now, I mean, in part where we are right now in a new administration, but where we are right now in our political history of the United States, is that I think it's probably time to recognize a new concept of the agency. It's that the vast bulk of the technical expertise really is in the private sector, can't be in the federal agencies. It's just, stuff moves too fast. There's too much of it. An awful lot of the criticisms of collaboration are as if Dick Stewart's transmission belt were still clanking away there in the background, the experts delivering the right answers. And, that model just doesn't work anymore. But also, it's time to recognize, and just listening to today, the number of ways agencies are buffeted already. I mean, you don't have the agency sitting in his closet issuing the decision. So you have OIRA, the White House, the President, Congress, courts, public participation. I mean, all these sort of pressures on agencies. And, add to that a lot of the trans-agency issues, the mega issues that Bob was talking about this morning. Time to take a look at it. And there are lots of ways of achieving the public goal. And so, I mean, it strikes me that the really critical part of the agency, the critical one where they did, and I guess sort of picking up on David's, is distilling out what the public need is, and then working with the parties as to the means to achieve those. So then let's look at the practical role, and then sort of want to flip over and talk about it. There's no question that the agency is the leader in any kind of collaboration. It's going to be the first among equals. It's going to stimulate it, and it represents the sovereign in the negotiation. It's also, it's a collaboration, but to a very real extent, it's a stimulated collaboration. Remember, one of the parties has an army. And parties may say, I don't want to reach an agreement on that. He says, well, we're going to come get you if you don't. And so, I mean, it can really kind of force people to making decisions. And that really kind of wonderfully famous remark of then SEC Chairman Douglas about that he wanted to rely very much on private decision-making, but made sure that he had a well-oiled shotgun behind the door. So the point is that the agency's threat to act is a major stimulus towards collaboration. People are going to collaborate in order to influence the decision. I want to talk about the agency's participation or not in negotiations. I've heard many times reports, and seen it several times, about how agencies think they are doing the parties a favor by saying, well, I have you on my left, and I have you on my right, and if the two of you agree, I will implement whatever you decide. And I don't want to do anything to inhibit the free flow of your ideas. Because if you come together, perfect. I'm right in the middle, and that's just where I want to be. And that attitude has problems in at least three dimensions, one of which is going to be intuitively surprising, I think. I mean, one is, a major part of the legitimacy of this whole process is it's the agency's decision. And we may have shared it with other people, but the agency decided this was the best way it was going to achieve its purpose, given the reasonably available alternatives. And so, otherwise it's not able to achieve its goal. Second is, if it doesn't participate, it's not going to enhance its own view. So, I mean, it's not going to get what it wants out of it, different means of enforcement, different process, different wording, whatever. The last one is really surprising. First time that happened to me when an agency said, we're going to take a passive role, the parties talk, and they talk, and they talk, and they talk a little more, but they didn't reach an agreement. Disbanded. Second time I saw it, parties talked, and talked, and talked. Same thing happened. Exactly. I said, this isn't a coincidence. So then you stop and think, why is this happening? The reason you negotiate with anybody about anything, if you can do it yourself, you do it. Why put up with that other nonsense? You're doing it in order to make yourself better off. And why are you participating in a collaboration, for collaborative governance in a RegNeg? Well, because you want to influence the decision, and you want to make it a better decision than if the agency did it alone. The agency's sitting there like a toadstool, saying nothing. So you don't know what your alternative to a negotiated agreement is. You haven't enough data to decide. And so what is the classic remedy for doing that? You talk. And so by being quiet in a collaborative governance situation, the agency actually inhibits agreement. Not helps, inhibits. So it needs to be an active participant. This is not a czar. This is not directing. Anyway, I think there's one other issue I do want to raise, because I think it is really critical. I mean, there's sort of a whole bunch of others that sort of running out, and I don't want to get to the executive order stuff. I think a major inhibition on collaborative governance, meaning reaching agreement, has been an enormous breakdown of communication inside agencies in the last 10 years. I mean, due to the political wars, and I want to emphasize this is not an anti-Bush. It clearly started in the Clinton administration, but across agencies, across a broad swath of agencies, if you look at carefully what's happening is the staff level and the political level are in different worlds. They don't talk to each other. I have on multiple occasions been at meetings where if you had the staff, you wouldn't get the politicals. If you had the politicals, you wouldn't get the staff. That's nuts. And we've got to break down that kind of partisanship and increase communication. Because if you have that kind of war, I mean, the number of times I've been told, if I'm retained by a political, don't talk to the staff about this. If you talk to the staff, don't talk to anybody political. A bunch of agencies. That's just got to be broken down. And I think that it's also important to take a look at ensuring that the whole idea of the collaboration, I mean, hence my title, the doing it right, is to pay attention to some of the details and be professional about how they're implemented. Too many agencies are taking too many shortcuts, thinking they know better when they clearly don't, and it just isn't good. And the results have suffered accordingly. Anyway, I suppose I had a filibuster until Don comes back. But anyway, let me talk a little bit about the executive order here. Okay. The current executive order, the drafted at the beginning of the Clinton administration, which is still in effect, provides that each agency shall provide the public with meaningful participation in the regulatory process. Each agency is directed to explore and, where appropriate, use consensual mechanisms for developing regulations, including negotiated rulemaking. Sounds good, right? I mean, I think as you heard Don largely in response to Jeff's question, very shortly after that, OMB made it very clear that it did not favor this process, that it didn't like it, and whatnot. So let's sort of take a look at some of the reasons. One is the president's the decider. The president gets to make the final decisions. Everything else is a recommendation to the president, so the president can just make wholesale, categorical changes. And as a result of that, there is an opposition. One of the oft-stated oppositions is, well, we don't like a result of a collaboration because then it makes it more difficult to change. And that, if the president decides he wants to go somewhere else, he's repudiating a consensus of varying interests, and that can be inhibiting. And so that inhibition, goes from the president on down. And so it interferes with plenary power, and decisions will be revealed. I'm firmly of the view that view is wrong, and it's wrong in a number of different dimensions. And I think just, by way of background, I am a strong believer in White House review, OIRA review. Indeed, I participated in the drafting of the first executive order and the creation of OIRA itself. And I, 20 years ago, gave a paper across the street supporting it in the teeth of fairly strong opposition. It was not a popular view at the past. So, come with that kind of background. So, why is it wrong? First of all, it's wrong as a matter of constitution. The Constitution, and this is, I'm going to give a two-second plug for Peter Strauss's article, in which analyzes it in some detail. But since the get-go, the very people who drafted the Constitution, then in the Congress, assigned the responsibility for implementing statutes not to the President, but to the officers of the United States. We conceded you, Don, we admitted that OIRA was going to support this while you were gone. That's how they've treated me for 20 years. Anyway, I think also that that's a good thing. I think that the tension between the President and the officers is important. On two occasions, I have watched one of those officers of the United States tell the President of the United States, I'm going to take this action, and the President has said, don't. And the officer said, I'm going to anyhow, and we're not fired. I think that forces the President to weigh the political significance and importance of it, and puts it into perspective, puts it into the public. I think I'm also of the view that it would have been a lot better if Christine Whitman had said, Giorgio, I am signing New Source Review this afternoon, and it's going to be in tomorrow's Federal Register. You have 2 hours to fire me, and it will be in tomorrow's Washington Post, and we would have known where the decision was. Raise it. We now know where accountability is instead of things happening under the table. So I think that it's important. And I also think that a major downside of presidential rulemaking, of the decider, is that it does diminish the role of agencies. And I think that it is a major component in the breakdown of communication within agencies that I and many others have witnessed. And then sort of lastly, given this week's news, it also strikes me, as one who spent the entirety of the 60s at the University of Michigan, that where GM really started failing was when those guys in the gleaming tower of the Fisher Building thought that they knew more about designing cars than the designers and the engineers. The President decided. You remember that bunch of crap they made in the 60s that they never kind of got over? They've been dying for 30 years. And I think that's another component of it. At any rate, so I hope, so I'm about ready to end here. So I hope that based on these memos and conferences like this and writing of other people, that the new administration will sort of address some of these issues and come up with a new executive order. So that memo that I put up on first sort of talks about some of the goals: transparency, public participation, collaboration, strengthen democracy, efficiency. All these good words. It's nice stuff. And I think that one ought to be able to achieve those goals and still preserve some of the important prerogatives. So let's take a look at what you mean. It strikes me that the really important role for the executive office of the President, be it the President himself, OIRA, CEA, CEQ, whatever the relevant words are, is it just as we've talked about, is it needs to set the boundaries. Just as it's the agency's role to do it in a collaboration, these are the agency's managers. And every person who's participating in a negotiation is going to get instructions from their management. And so it strikes me that this is part of the role of the ex-op at the beginning. They're not at the table, just like the management of the negotiators are not at the table. There's a feedback loop back and forth and acting within the constraint. And let's see. So still will review the rule. I'm very strongly of that view that is an important function. But I think that, if you disagree with it, you need to explain why. I mean, for the same reason of the kind of creative tension talked about before. All right, let's see. So another one is to check back. And I'm sort of along the lines that Michael Hirsch was talking about in judicial review. I think that XOP could also play if it is a collaboration, we're the right people there. All right. So I said there is a docket on the revision of the executive order, and maybe we'll sort of focus it, or I don't know whether maybe we want to just break after this and have lunch and come back, whatever. Anyway, there is I submitted a proposal to that docket, of which I distributed the substance of it. And it's really kind of interesting because the person who commented about five people after me sort of talked about how wonderful cost-benefit analysis is, and whatever you do, don't do what Harter suggested. So it was kind of an interesting aspect to read a docket with a first remark is an ad hominem attack. But at any rate, so what do I propose here? I mean, I think that it would be appropriate for the executive order to largely echo the Clinton executive order and urge a collaboration. And I think in doing it, it needs to consult with the major constituents, and it needs to define what it's going to do. Goal, both the process and the goal up front. Then I think if it's going to set policy, what does it needs to do? Do some convening outreach, needs to publish a notice to make sure the right folk are there, needs to actively participate. I think it needs to consult with OIRA. As things are narrowing down, needs to consult with it up front. What are the goals? But as it's narrowing, here's where we think it's going. Do you have any major concerns here? So that they can be factored in at the table, just as all the parties are checking with their management as well. Needs to explicitly concur, not kind of be vapid, but it needs to make clear that the agency is on board with it. And so anyway, and go on. And then it strikes me that if it does all that, then the OIRA review ought to be able to be more brief, more attenuated, probably supported with less data, which we could go into or whatnot, which is really actually very much what the process was in much of the Reagan and early Bush administration. It really was much more of an acceptance and a quicker review, which was a major incentive to use it. Anyhow, I went on too long. So do we want to debate all this stuff now, break for lunch, and why don't we break for lunch and come back? Is that? Lunch! Yay, get Harter off here. Yay! So with any luck, that's the last speech Harter's going to give. You guys won't have to listen anymore.